NACDL is the association of the nation's criminal defense bar.
Jeff asked me to talk about, why it is that I'm so focused on prosecutors. And I think the reason is because I was a public defender for 12 years in the District of Columbia. And I will tell you from my work there, I was always shocked, surprised, fascinated, angered by the power and discretion of prosecutors. It just blew my mind that they had all of that power, that they were able to do what they did, and they really were, and the actions they took, their practices, their policies, created tremendous injustices in the criminal justice system. Sometimes because they were engaged in prosecutorial misconduct, but quite frankly, sometimes what they were doing was not really considered misconduct. It was legal, it was permissible, but it still produced these results that were incredibly unfair and would be seen that way by any person who understands what justice and humanity are. And so I just couldn't figure out how are we allowing this to go on? How can this be legal? And I talk about it a lot in my first book, Arbitrary Justice, The Power of the American Prosecutor. Much of the book, people say, oh, it's a book about prosecutorial misconduct, but actually it isn't. It's a book about the everyday business that prosecutors engage in that end up creating results that really are not fair. People who go to jail even if they are guilty, for far too long, incredibly unfair sentences. Of course, wrongful convictions, we know about those. Those are incredibly unfair. We all know that. Horrible racial disparities that I think are partially caused by prosecutors and perpetuated by them. And they never were held accountable for them. And so when I became a law professor, I just decided that this was going to be my area of research, that I was going to figure out how could this be in a democracy, right? How could we allow this to happen? And so I've spent a lot of my years, pretty much all of my academic years, focusing on prosecutors and on racial disparities in the criminal justice system, but with a specific focus on the role that prosecutors have played and continue to play in creating and perpetuating those racial disparities. And I hope to talk about that a little more when Jeff and I start to discuss this together. So I don't want to talk, you guys know much of how this happens, and so I don't want to say, so forgive me if I'm saying things that you already know, because I know you already know them, but I'll just put some basics on the table that I know you already know, which is that prosecutors pretty much control this criminal justice system that we're in, folks. And they do that through the charging and plea bargaining decisions that they make. They control charging decisions, they control the plea bargaining process, and the control of those two aspects of the criminal justice system really allow them to control this system altogether. Especially when, as I'm sure you all know, 95% of all criminal cases are resolved by way of a guilty plea. All folks who are not in this room, who are out here, who watch TV and watch all the 5 or 6, 7 different Law and Order versions on TV, think that there are all these trials going on, but as you and I know, they are not. There's a whole lot of guilty pleas going on. And as many of you know, the process is not a fair process. I'm sure we're all familiar with prosecutors who overcharge, who pile on charges simply because they can, because all they have to meet is a probable cause standard, and they're piling on charges, many of which they know they can't prove beyond a reasonable doubt ultimately, and it gives them this tremendous advantage at the plea bargaining stage when you're representing a client who, when faced with 5, 6, 7, 8 mandatory minimum offenses, would probably plead guilty even if he or she were innocent. And we all know of cases of innocent people pleading guilty simply because they're afraid to go to trial because of the risky business that trials are. And that's not the way justice is supposed to take place. I don't know how many of you have been in the situation. I was fortunate to be in D.C. I was not often put in the position that I'm about to describe, but I know that many defenders across the country have been, where they get an indictment, or even if it's not an indictment, it's a complaint or whatever, and there's tons of charges there, and the prosecutor comes up to them on day 1 or 2 and says, I let your guy plead to 1 and I'll dismiss the other 5. And you're saying, well, wait a minute, I haven't had a chance to investigate the case. It's my ethical duty to pursue the best defense possible for my client. I haven't had an opportunity to investigate. And the prosecutor's like, too bad, the deal expires tomorrow. And then you're like, well, what am I? What am I supposed to be doing as a defense attorney? Do I have a use here? I mean, you're put in a position where you can't even advise your client. I know of defenders, I've talked to defenders who felt helpless. It's like, I feel like I can't not tell the client about the plea. That would be unethical. But if I'm telling them about the plea and I'm not in a position to even advise them about whether it's a good deal or not, what am I doing? Am I breaking the ethical rules because I'm not zealously representing my client? But you're put in that difficult position. And that's not what justice is supposed to look like in the United States of America, but it looks like that. I don't know how many of you may have seen the PBS documentary, The Plea. Has anybody seen that documentary? Yeah, and those of you who have your hands raised, I'm sure you'll agree with me that it's worth watching. It's online. It's a fantastic documentary that really, so it's almost 10 years old now, but it's still, unfortunately, what goes on in that documentary still remains true. So with those two powers, the charging power and the plea bargaining power, and the fact that so many of these cases, the vast majority of them result in pleas, they're really, these prosecutors, they're almost predetermined. When you take into account that there's so many mandatory minimums, they're pretty much predetermining the outcome of criminal cases. And so they're doing all of this, and there's so many disparities, which we'll talk about in a minute, that result, right? Because when there's discretion, there's the potential for, and in fact, there are disparities, race disparities, class disparities, where poor Black and brown people all get a worse deal than white wealthy folks, and all the statistics bear that out. But it happens because they make these decisions behind closed doors. We don't know, unless it's a high-profile case of some sort, or there's some investigative reporting that reveals some horrible injustice, we're not aware. So if the 1 or 2 or 3 cases that we hear about, the high-profile cases, you can imagine that obviously there must be more of them going on. And so my focus has been on how can we stop this, right? What can we do? What is the answer? My good friend Paul Butler, some of you may be familiar with his work, and he has a fabulous book out as well now called Chokehold, subtitled the same as my main title. So it's Chokehold, Policing Black Men, fabulous book I recommend to you, and he's done other work as well. And Paul and I have had an ongoing argument for decades, because Paul's view is, I think he has an article out called Good People Should Not Be Prosecutors. I believe that's the title of it. And he's serious. And so I'm thinking, well, what's the alternative? Bad people should be prosecutors? I mean, come on, Paul. But his thing is that you can't be a prosecutor and just remain to be a decent person. I'm like, Paul, okay, really? Well, and so Paul he also calls himself a reformed prosecutor because he worked in U.S. Attorney's Office as a special. He just worked at the Justice Department. I don't know how you all know how that works. Sometimes they will leave for a year and go and prosecute cases in D.C., and he did that, and that experience, he said sort of changed him, and he just so now he just hates all prosecutors. I'm not in that camp, because I really think that we would prefer that good people be prosecutors than bad ones, and we are going to have prosecutors, and we should have prosecutors. The question is, how is it that we have a system of prosecution that is a fair and just system? And I think it's complicated. How do we do it? Well, first of all, about 10% of all criminal cases are prosecuted on the federal level. How many of you have a federal practice in here? Federal defenders? Okay, quite a few. And the rest of you are on the state level. So about 90% of all criminal cases are prosecuted on the state and local level. And in every jurisdiction except 5, prosecutors are elected officials. They run for office. And so there are thousands of state and local prosecutors, county prosecutors, some city prosecutors, who run for office every 4 years. And they're the only politicians, I think, that we just, as a society, just really do not hold accountable. I mean, when most folks run for office, they talk about what they do, talk about what they're going to do, talk about what they've done, and then people hold them accountable for that, and they pay attention to them, and they watch them throughout the tenure to make sure they're doing what they're supposed to do. They call them up. If it's the mayor, remove the snow from the sidewalk. If it's whoever it is, a city councilman, I am having a problem with this in my county. Nobody's calling up the prosecutor saying, so what about those charging policies? I mean, that sounds silly, but the point is that nobody holds this particular elected official, in my personal opinion, accountable in any meaningful way. And why is it? Well, of course, unless you or a member of your family is involved in the criminal justice system, you kind of, nobody's really like checking on that. I mean, you kind of understand it. Why nobody is going to, if you don't have a case yourself, or you don't have a family member with a case, or if you're not a victim of a crime, whatever, nobody's really like checking on the prosecutor. And so they're doing what they do, and they do it behind closed. All they do in open court is what you see in open court, which is a status hearing and the occasional, and I do mean occasional, trial. The real meat and potatoes of what they're doing is that charging and plea bargaining stuff, which is done behind closed doors with absolutely no transparency. And the way democracy is supposed to work is that transparency is just an essential part of democracy. Without that transparency, we really can't hold people accountable. And so they're the most powerful officials, and we hold them the least accountable. And that can't be. And so much of my work lately has been focusing on a lot of things. Like throughout the years, I've thought and read about a lot of different things. One solution, not really a big solution, but one issue, I should say, that I focused on is, holding prosecutors accountable when they violate the rules of professional responsibility. And every time a prosecutor violates Brady, they violate the rules of professional responsibility. So in all states, I think California is the only state that doesn't follow the model rules of professional responsibility, but California still has its own. I'm sure that, in fact, California is doing some really innovative and creative things around holding prosecutors accountable, more so than other states. But most other states follow the model rules of professional responsibility. And there's one rule, Rule 3.8, that applies solely to the function of prosecutors. And Rule 3.8 covers a lot of things. It covers charging practices, plea bargaining practices, it covers trial practices, but it also covers Brady. And actually the part of 3.8 that's the Brady part is actually stronger than Brady, the case, right? It actually has puts slightly more obligations on prosecutors than 3.8. And prosecutors violate Brady every day. There's a prosecutor right now, thousands of them, as we speak, violating Brady. Right now. And nothing happens to them, as you know, because no one refers them to bar counsel. Well, I understand why public defenders, and quite frankly, all defenders, I kind of get it, why defenders are hesitant to refer prosecutors to bar counsel. Because, once you refer a prosecutor, then you're persona non grata with that office. Your future clients will never get a good deal. That's not fair. It sounds retaliatory and vindictive, but I'm not sure what the remedy would be if that happened. And it would be subtle, but it would be meaningful if you would feel it if you did that. So I understand why they don't. I frankly do not understand why judges don't refer. When a judge finds that a prosecutor has engaged in misconduct, why isn't that judge referring that prosecutor to bar counsel? They don't have to get deals from them. Why aren't they doing that? And I think sometimes I think it's because in some jurisdictions the same prosecutors appear before the same judges. If they have this kind of cozy relationship with each other, like sometimes there'll be a team of prosecutors that appear before the same judge all year or whatever, and they have some of the judges come from prosecutors' office. I mean, we had a conference at my school some years ago, and we had some judges there. And I asked that question. They were on a panel, like, why don't you? And one of them said, and I really had to restrain myself because I didn't want to get locked up, But one of the judges said, oh, but it would ruin their lives. And I almost like dove at the screen because I'm like, seriously? They are sending people to death row. They are sending people to prison for life, for decades. Wrongful conviction. You worry about ruining their life over a little jive bar counsel refer? I didn't say all that out loud, but I was thinking that. I said a milder version of that. But I felt, really, I thought that was so offensive. There are a few judges that do. Judge Emmett Sullivan, who is a federal judge, United States District Court for the District of Columbia, who routinely, I won't say routinely, but he routinely is too strongly, but he doesn't hesitate in appropriate cases. I mean, not every Brady violation, because there are some that are more egregious than others, but some are just egregious. And when it's egregious, what is the excuse for not referring? He has referred prosecutors to bar counsel when they have violated Brady and done other things. But most judges really will not do it. But I do think, and so if you look at, and I think the Center for Public Integrity did a study some years ago about the number of prosecutors who were referred to bar counsel, just like a handful, and then in an even smaller percentage of those who were actually found, held accountable for something with either a suspension or whatever. I mean, the case that most people know about, ironically, is the Duke Lacrosse case that happened some years ago when Mike Nifong was referred for bar counsel for violating Brady, which he did, and he should have been referred, but he was disbarred. And I'm crying no tears over that. I mean, he should, but his case was not the most, it was egregious, but there are some prosecutors that put folks on death row because of their egregious Brady violations. And they didn't even get referred to bar counsel, much less something happening to them. I'm sure y'all are familiar with the Connick versus Thompson, or is it Thompson versus Connick, United States Supreme Court case. One of the most egregious ever, where poor Mr. Thompson spent decades locked up. When this prosecutor finally on his deathbed, I guess he thought he was going to get to go to heaven if he confessed at the last minute. I don't know about all that. Anyway, whatever. But he confessed to an egregious Brady violation. And, they ended up releasing Mr. Thompson, and he was awarded millions. And, of course, it was reversed, and the Supreme Court upheld that per Justice Thomas. I won't get into that. But, the point is that, nothing happens to these prosecutors who do these things. And that really has to change. And I've had all kinds of ideas about, even if defense attorneys don't feel comfortable doing it first. Quite frankly, most jurisdictions, anyone can make a bar referral. You don't have to be the lawyer in the case, you don't have to be the prosecutor. Anyone can make a bar referral, and it's up to the bar counsel to investigate it and so on. So that's the bar thing. And then I'll say one more thing, Jeff, and then we can. So I've been focusing a lot on that, and also focusing on the election of good prosecutors. Because there are some, and I think good people, I disagree with Paul, I think good people should become prosecutors. And I think we've seen a few examples, not enough, but a few examples in this last election of decent people who have run for office, who have challenged sitting prosecutors, and that's no easy feat. I mean, to challenge an incumbent in any race is almost impossible in this crazy money system we have in politics. But there were some decent prosecutors who were elected this last go-round. Aramis Ayala in Orlando. Kim Fox in Chicago is also a really good person who's doing decent work, I think. And then there are others who've actually been sitting prosecutors for some time. John Chisholm, I mentioned all the time in Milwaukee County, Dan Satterberg in Seattle. So there are some decent people who have run for office and are trying to change things and do things a different way, a different vision of prosecution that sounds a lot more like justice, right? Instead of, Supreme Court says, as y'all know, it's not the duty of prosecutors to seek convictions, but to seek justice. And that's also a comment to the model rules of professional responsibility, which they are bound by. I wrote an article last year called The Prosecutor's Ethical Duty to End Mass Incarceration. And it's not, I'm not saying that as some kind of cute law review title. I really mean that. And I try to ground the article and not just some broad sort of ethical concept, but in the model rules. And I make an argument that the model rules require them to do that, because the model rules talk about prosecutors having this broader responsibility to be a minister of justice and have a responsibility for promoting the fair and just administration of justice, the fair administration of justice, broadly speaking. And there's no issue more critical, in my view, than this problem of mass incarceration and the problem of racial disparities in the criminal justice system. They have a responsibility. Their actions help put us there, and they're largely responsible for it. And so, in my view, they're largely responsible for fixing it. And I think there are things that they can do to fix it. And so that's why I focus on prosecutors. That's why I think we have to focus on them. We have to make them do what it is they're supposed to do, and do it fairly, right? And which is to seek justice. And seeking justice does not always mean seeking a conviction. Seeking justice sometimes means dismissing a case. Seeking justice sometimes means advocating for the release of people who have been in prison way too long and shouldn't be there anymore because they were sentenced to unfair long sentencing terms. And so it obviously means freeing the wrongfully convicted, that's a given. But the wrongfully convicted, that's a given. But it also means helping free some people who were convicted but who've served enough time and need to come out, right? Because nobody needs to be in prison for their entire life. So, when people are too old, and there are people in prison who are too old to be a danger to this community if they ever were, and so why are they still there? That's not just. So I think we got to push them, really, to do what it is they're supposed to be doing. It's not what they're doing now. So I'll stop right there.
And I just wanted to, I wanted to sort of go back to something that you just talked about, the article that you wrote talking about the prosecutor's ethical duty to end mass incarceration, and to take that back to the stage of the charging decision. Can you talk a little bit about, at least what I have perceived in my practice is that, and I think maybe this is written somewhere, some prosecutors feel that their ethical duty is to charge the most serious crime that they can possibly charge based on the evidence, and then to hold a defendant accountable that way. I think we may have even heard that from Jeff Sessions. Can you focus a little bit on the charging decisions and what kind of impact maybe we could try and have there?
Right, so that there is nowhere that there's no ethical rule that says or would even remotely support the notion that it's the ethical duty of a prosecutor to charge everything they can possibly charge, right? Because first of all, as we all know, charging, probable cause. We don't know what probable cause is. It takes almost nothing to meet probable cause. It's nowhere close to the proof beyond a reasonable doubt that's required to convict a person. There's some prosecutors who tell me, I don't know if they do, and I've been trying to talk to prosecutors, that, I don't bring a charge unless I know I can prove it beyond a reasonable doubt. Well, I can tell you right now, most prosecutors are definitely not abiding by that policy. What they're doing is they're piling on charges to give themselves an advantage at the plea bargaining stage so that your client is looking at a list a mile long, and then they're feeling like, oh my God, I better plead guilty. I better take this offer. I'm going to end up being convicted of all these charges. I'll never see the light of day. And you can see how an innocent person would even plead guilty. But I'm sorry, I'm losing track of your question.
But is there, I'm wondering about things that we might be able to do both as defenders and as people who are working in civil rights organizations to have an impact on the charging policies that the prosecutors are making. Where have you seen, what kind of things have you seen that will actually have an impact on making them think about what they're doing and maybe change what they're doing?
Well, I think there's some innovative things going on, conversations going on around. So, for example, John Jay College has now an Institute for Innovation in Prosecution, where they are really trying to bring together progressive prosecutors to talk about these issues and to maybe educate them, to the extent they aren't, about the impact of their charging policies and their charging practices on this whole criminal justice system that we have, and to get them to think about their role different, to rethink the role of prosecutors, because the main thing they do is charge and offer plea bargains when you think about it, because they're not trying a lot of cases. So I think we have to try to get prosecutors to rethink it, and quite frankly, just get new, different people. We have a couple, some former defense attorneys, Krasner in Philadelphia and others, Mark Gonzalez out in Texas, former defense attorneys. And I know the notion, I know you're all probably thinking, I'm not going to run for prosecutor. I get it. I'm not getting ready to do that either. But I applaud those who are, because they are coming at it from a different perspective. They're not coming at it from this notion of my job is to lock up everybody, right? And I just think far too many prosecutors, Jeff Sessions obviously doesn't understand the role. They don't really understand. I don't know where this notion came from, because it's not written down anywhere. My job is to convict as many people as possible. You will not see that in any ethical rule that applies to prosecutors. You will not see that in any treatise. That's not supposed to be their job, but somehow that's become, in their mindset, their job, is I'm supposed to just lock up as many people as possible. So I think we have to work through organizations and projects like the one I just mentioned to try to educate. I also think it's the role, quite frankly, because I don't think we're going to be able to do it in this room, I think it's the role of prosecutors who do get it to talk to their fellow prosecutors, because they'll hear it from so I hope that people like Kim Fox and John Chisholm and those folks, they need to be going to the National District Attorneys Association meetings and all these other places and standing up in front of everybody saying, look, I'm doing this differently. And John Chisholm can say, and I got reelected a couple of times, even though I instituted this program to reduce racial disparities in my office. My constituents reelected me because crime did not go up when I started instituting policies that resulted in fewer people getting locked up. Crime didn't go up, I got reelected, and you all need to do it too, and here's why. He needs to tell them about the horrors of mass incarceration. He needs to be the one, not that we can't, but I think he has a bigger voice, and it's not just John Chisholm. There are quite a number of prosecutors who get it, not enough, I say quite a number. There are thousands of prosecutors, I know maybe about 20 out of those thousands that I know of. Hopefully there are more. But some of them have big pulpits because they're ahead of large jurisdictions. And I'm pushing them to go out and be the messengers.
Filing a bar complaint against a prosecutor who has violated Brady in an egregious way, and how that can be a difficult thing. And I also asked you about, does our adversary role get in the way of us trying to go to prosecutors to talk about policy issues? Mm-hmm. And I'm wondering if you could talk about that and maybe the role of leadership in public defender offices, or even in state bar. If you're in private practice, there's a state criminal defense lawyer association.
Yes, thank you for that question. I think it's a really great question and an important one. You know, I used to run the DC Public Defender Service, and I would never ask the public defenders in that office, with their caseloads, they're out there fighting, I would never ask them. In fact, I don't think they should. I want them to be adversary. They're supposed to be adversary. I want them to go across the street and kick butt, right? I used to tell people all the time, like one of the job qualifications for working at PDS when I was the director and before and after is you have to have a healthy disrespect for authority. Because if you don't, then you got to. Why? Because I want you to be fierce. I want you to go across that street like our little emblem was like a knight in shining armor. I want you to go across this street over there to 500 Indiana Avenue and be fearless. Fearless of the judges, of the prosecutors, and fight for your clients and stand between your clients and all those other folks. So I don't need them being cozy with anybody. Just do your job and be fierce. But I do think the chief, like the head of the public defender office, can have some conversations with the head DA, but I don't want them to do it by themselves, right? I think that it's like in a number of jurisdictions. I see Mark Maurer in the audience, director of the Sentencing Project. He has been sort of groundbreaking in this work of bringing together, and this notion of bringing together the chief actors in the criminal justice system, the chief DA, the chief prosecutor, the chief judge, the head of probation and parole, community members, and to create sort of these task force that really look at the whole system, because really even the chief defender shouldn't do it by themselves. But for everybody to come together and say, okay, let's look at what we have here. We've got a situation where we're locking up all these people. There are people on money bonds where they're being locked up for almost longer than they would serve if they actually had the sentence. There are all kinds of problems, including the racial disparities. And that's the project that that they talked about, creating in these racial justice task force, which have been implemented and been quite successful. But getting back to your point, we need people who are in those chief positions to have these conversations with the chief DA. And I say it's better to have it with a group of people. But we also need not just people in the criminal justice system. We need like the bar, the American Bar Association, your local bar association, people who are not doing the criminal justice work. They need to stand up for this too. Your president of your local bar, the president of the ABA. And I will say the ABA they have sort of done this. It sort of had other people. Because, everybody's got to, it certainly can't just be us defenders, Lord knows. I mean, they don't listen to us. Other people need to step up who understand that the system we have now is an unfair, unjust system. And I'll tell you, as more and more people, because so many people are getting locked up, more and more people are having their families, their lives affected by this. And it's sad that it has to come to that point before they decide that they care.
So just to follow up on that, and I'm thinking about what I know about lawyers in the DC Defender's Office and lawyers elsewhere in terms of contacts that we will have in the communities because we're representing our clients, and maybe contacts with pastors, contacts with other people in the community. Is that too much outside the normal area of public defender work to be involved in making those kind of connections?
Absolutely not. And again, when I was at DC, I was not pushing, because I knew the lawyers there, they're working so hard, they're doing their caseload. I'm not about to ask them to go to a single community meeting or do anything, because they're working so hard. I don't feel like I should be putting that responsibility. But I went out and I talked, and I still do. I mean, I try to spend more time talking in churches than I do at law professor conferences. I try to avoid law professor conferences, quite frankly. Hopefully there are no law professors in the room and I'm offending. But I feel like I want to spend most of my time, and I think those of us who are in a position at the ACLU and at NACDL and at the NAACP Legal Defense Fund and at the Lawyers Committee, we do need to be out there going to churches, and synagogues and mosques and community centers and schools and wherever someone will listen to us talking about this. I will tell you, right after Ferguson, I was invited to do a talk at Metropolitan AME Church in DC, which is one of the bigger black churches in DC. And it was a panel to really talk about what happened in Ferguson. And I was on a panel with Angela Also Brooks, who is now running for something else, but she's the prosecutor for Prince George's County in Maryland. And I think it was Ron Macham, I think it was the previous U.S. Attorney for the District of Columbia, Chris Henning, who is a defender who's at Georgetown, who runs a juvenile. So it was me and Chris and like two prosecutors on this. I think I was sitting like between two prosecutors. But we talked to a packed house of people from the community. And when I talked about the role of the prosecutor, the grand jury, why it is that prosecutor did not prosecute the cop who killed Michael Brown, people were stunned. I mean, a very educated, engaged crowd of church people coming up to the mic, and they just couldn't believe it. What do you mean, grand jury? What do you mean the defense can't be in there? What do you mean? They were shocked. They had no idea that prosecutors had that much power, and they were fired up. And so that's so important, because really this is about, them making that change, removing these people, right? And so I think that's incredibly important that we do that kind of talking and to people and engaging with people. And I mean, I tell people, ironically, it's these horrible killings of these unarmed black men and boys in the past several years that's really opened the eyes of the public to prosecutors. Because after they finish, and they don't finish being outraged by the killings, but the first thing they think is, what do you mean the prosecutor is not going to be charged? I just saw of him murder somebody on videotape. He's not being charged. I mean, people are outraged, and rightfully so. Or in the few handful of cases where they charge them, what do you mean not guilty? You know, so people get it, but we really have to do a lot of the hard work of getting out there, educating people, and engaging them. I think that's very important.
When you have, you've mentioned a couple of times issues of racial bias in, and let's focus on charging decisions. Has there been some success in getting prosecutors to examine that? And if they won't accept our word for it, you know, a public defender, the head of a public defender's office comes in and says, we have 80% of the cases in this county. We're looking at the cases we have and we see an absolute racial disparity. And the prosecutors are feeling like, well, that's anecdotal. Is there a way that you have seen where there have been successful attempts to get prosecutors to essentially analyze the data? Song Richardson talked about the importance of this a little bit.
I have. And before I talk about the particular project, though, I will say, do y'all know this case, Armstrong versus United States? So it's it's one of the many, many horrible United States Supreme Court cases, but it's a really horrible case about what defense attorneys have to show to get discovery in cases in which they are claiming selective prosecution. Not what they have to do to win this case, but what they have to do to get. So the case, just very briefly on the facts, it was out in Los Angeles. And so the public defender, the local public defender office was anecdotally seeing that with their clients, that the few white clients that they had, but the ones that they had were being charged in state court for the cocaine distribution and cases, and all the black clients were being charged in federal court. And we know what that means, just in terms of the sentences. They were harsher in federal court, and that was pre-Booker, so sentencing guidelines were even mandatory. So they were like, what's going on here? All the black guys are getting... And so they decided to file a motion in Mr. Armstrong's case to dismiss based on selective prosecution. But they needed some data. So they needed, so they filed a discovery motion asking the prosecutor to produce just not names or anything like that, but just the number of white defendants that you've charged in state court and federal court, and the number of black. And the prosecutor opposed it, and just cause they could. I mean, they have a basis. But the judge, you know, I forget the procedural, whether it was granted an appeal. Bottom line is it went all the way to the Supreme Court, and the Supreme Court said, they don't even have to give discovery. I think it says something like, in order to get discovery, the defense has to show that similarly situated white defendants could have been charged but were not. And that's to get discovery. I'm thinking, I thought you won. If you could show, think about it. If you can show that similarly situated white defendants could have been charged but were not, don't you show selective prosecution? Isn't that how you win? So it's a horrible, horrible case. But I say all that to say data. Yes, we do need data. Although, of course, those of you who know the McCleskey case know that even when there was data, the Supreme Court says, you know, the data isn't enough. You got to show intentional discrimination. But I'm talking. Those are litigative. That's the litigation part, and it's not good news on the litigation side. But let's get back to talk about the policy side. For the policy side, yes, you need data. And so I think I may have mentioned briefly before. If I didn't, I've been talking so much lately. I don't remember where I've said what, but. There was a project that the Vera Institute in New York instituted some years ago called the Prosecution and Racial Justice Program. And it was a pilot program. It has ended now, but several prosecutors participated, and I think the one who participated in it most successfully was John Chisholm, the prosecutor I mentioned out in Milwaukee County. And the whole purpose of it was for, they basically asked for volunteer chief prosecutors to participate in the program. And John Chisholm was one of the ones who volunteered because he's someone who cares about racial justice. And he's like, I don't know if there's racial disparities in my office and I'm causing them. I want to know so I can fix it. So you need somebody with the will, first of all. But what it involved was the statisticians from Vera basically going in these prosecutors' offices and doing some very sophisticated statistical studies that basically would collect data on the race of the defendant and the race of the victim at various decision points in the process, at the charging, possibly plea bargaining, possibly sentencing recommendation, and some other steps, to see whether or not the race-neutral decision-making of these prosecutors was in fact creating a racial disparity. Like, unbeknownst to them, they're creating that just because they're doing certain things. And they did it in a few different offices, but I'll focus on John's office because he actually did something about it. They found that with certain types of cases, I think it was like some drug paraphernalia cases or something, that they were making certain decisions that were producing these unwarranted racial disparities where black folks were being charged and prosecuted and whites weren't. And once he figured it out, he fixed it. He's like, oh no, we're not gonna do that anymore. And he stopped it. So the thing about that program is if you go to their website, they published a guide for prosecutors that any prosecutor's office can follow to try to figure that out in their own office. And I wish that was like being handed out at the NDA meetings. It can be done. He's not the only one who did it. Cy Vance in New York participated in. Years ago, Peter Gilchrist, who many years ago used to be the DA down in Charlotte, he's since been gone, he participated in it, and he actually found disparities there and he changed it. But then a new DA was elected who didn't care about that, so he stopped the whole thing. That's why this whole election thing is so important. So I think that's one model that has worked, that I would love to see spread out through prosecutors' offices.
When I want to go back for a minute to the adversary relationships that line defenders have versus the higher-ups in the offices, and to focus not only on the conversations that you've been talking about policy, but to go back for a minute to Brady. What about having all Brady complaints against individual prosecutors filed by the head of the public defender's office as opposed to any individual lawyer? So
you mean like having them file like bar complaints?
Bar complaints, yes.
I think that's a great idea, the head of the office, because if they would be hard pressed. I mean, what are they going to do? Not give anybody in the whole office a good plea bargain because they're mad at the chief? I don't think they could do that.
Right.
That's a great idea. Jeff, thanks for coming up with that. I had not thought of that. Because I had this crazy idea that my colleague thought was crazy, that I was going to make myself, I don't know, I call myself an ombudsman, but I think it should have been watchdog. I was like, I'm a law professor, I'm tenured, I don't care what they think of me. Why don't you let all the defendants call me up, send me the thing, I'll file it in my name, because anybody can do it, I'll do it. And so she's like, how's that gonna work? But I think your idea is a more practical way of doing it. I think that is a good idea, and I haven't thought it through because you just brought it up, but it sounds like a great idea worth pursuing. I think there's a way it could be done.
And I have a couple of other questions to ask, but if there are other folks out here who have questions, please feel free. And I'll just stop for a minute to see. Please.
I was the reporter for that report. The person who wrote up the report, yes. I'm familiar with it. It was called the Justice Kennedy Commission or something, because just to give, I'm going to let you ask your question, but just to tell everybody. So Justice Kennedy, back in the 90s, came to the ABA annual meeting, and it was, he's going to make a really big, important speech, and it's going to be shocking. And so what he said was, there are racial disparities in the criminal justice system. I was like, wow, really? And he said, and these mandatory minimum sentences, they're really harsh. And we have really locked up too many people, and everybody was, wow. So anyway, I'm being facetious, but I guess to have Kennedy say that, then of course, why does he vote the way he votes though? But that's a whole nother story. Anyway, go ahead. I just want to give them the background. Yes.
Saying the same thing. So my assumption is the initial reaction to the ABA request in the 90s must not have gotten a lot of traction. Mm-hmm. Do you see that a change in the response to the renewed request from the ABA and the NAACP Legal Defense Fund?
Do I see, what's the question? Do I see a change in?
Yeah, in terms of a better response, in terms of jurisdictions or entities that are actually forming these types of task forces within their localities to address racial disparities in
Right. So I mentioned before Mark Maurer's work, and it really came from his idea. But they did do, the ABA did, because my colleague Cynthia Jones worked on this for a whole year with a number of different jurisdictions where they did do just that, where they had these task force, where they would bring together the chief DA, the chief public defender, and they would work on these issues. And I will say the one entity, and I'm not all of them, but the one official that was always pushing back and not cooperating was the prosecutor. And here's one of the ways that they were not. The data that they needed, a lot of it needed to come from the prosecutor's office, and they didn't want to give it up. They weren't even asking for names of witnesses, and we don't need that kinds, and we need data, we need numbers. And several of them, and I won't call names, were resistant to turning that over. I think some of them were more successful than others. I know Mark probably knows better than I whether they're still going on. Whether there are any going on. Some he says, yeah, not so much. But I still think that's a great model. We just need to have the will of people to formulate those models, because where they've worked, they have worked.
This is actually just a resource thing that I wanted to state. The Innocence
please.
Project has a dedicated attorney who is prosecuting the prosecutors. So Nina Morrison is her name, and she's achieved one big success in the Michael Morton case in Texas, where Ken Anderson was actually sent to prison for 10 days. And so she's asking if you have cases where there are egregious violations of Brady or any other prosecutorial misconduct, or there are offices with systemic issues, that you contact her with those cases, because that is what she is here to do. So
that's fantastic.
Exactly
Thank you so much. I didn't even know that.
Her email is nmorrison@innocenceproject.org.
And her name again?
Nina Morrison.
Nina Morrison. And is it only cases involving wrongful convictions that she's dealing with?
Not at all, as long as there's misconduct. And,
excellent.
Yeah, something.
Great. Thank you so much for that.
Connecting with the community and getting the word out to the public, and I think goes to what we said earlier about the jury. I'm a member of our local NAACP, and what we've started a couple years ago is now a twice-a-year expungement clinic. But the big part of that is we get articles out in the paper about the consequences, and people like, I didn't know that could affect your public housing. I didn't know that could affect your ability to get student loans in college. And so having the clinic obviously benefits the people who come. They get free legal advice for volunteer attorneys, but it also gets the word out into the community about a lot of collateral consequences of criminal convictions that people didn't know about.
Yeah, thank you so much for that. And they've been doing some of those near me. So I live in Silver Spring, Maryland. I'm right outside D.C. Baltimore's doing. Okay, excellent. And I mentioned Angela also Brooks, who is the state's attorney for Prince George's County, now running for county executive. Her office, and we had some issues with this, but her office, the DA's office, sponsored a number of expungement fairs. And so this created some issues, as you're put on you all are defense attorneys, so you're thinking, wait a minute, how are they going to do that? Because it's like they would be there, and they would sort of, when people would come to see if they were eligible, they're looking up people's records.
Right.
And then if they discover people have outstanding warrants, okay, this is a problem. What are they going to do? Ignore it? So we kind of think, so what I think they ended up doing is a number of the criminal defense clinics, Michael Pennard at the University of Maryland and Jenny Roberts at our clinic, kind of talked to them and said, maybe you want to just let some defense people do this. Thank you. It's great. Advertise it, fund it, provide the space. But there's a kind of a conflict. But having it done through the NAACP, perfect, is so incredibly important. So that's incredibly important. And I'm glad you mentioned NAACP. Talking about organizations who sort of can take the lead. There are so many who have. The ACLU, your work, Jeff, certainly, obviously, NACDL has been doing this work all along, but other organizations that have not been focused on it. And so the ACLU has not always, in its history, been focused on criminal justice. And I have to applaud the ACLU now for the great work they're doing, hiring Jeff and all the great racial disparity work they're doing, but also the NAACP Legal Defense and Educational Fund, under Sherilyn Ifill's leadership, has also done and is doing incredible criminal justice reform work. And so it's good to see other organizations that are not sort of typically just, criminal justice are starting to step up, and they have these larger constituencies. It was not always the case, because in the past, I remember being one of these people that just sort of trying so hard to get the Lawyers Committee for Civil Rights, NAACP, not the Legal Defense Fund. Again, everybody knows it's two different things. There's an organization and then there's a law firm. But the organization with the members, they didn't want to touch criminal justice a while ago, long time ago, because it was like, crime, we don't really want to touch that, and we got all this other stuff too, voting, education, we'd rather do those issues. But I think they're all not stepping up because they're understanding this is the civil rights issue of our day. And I think people are finally getting that.
So one thing I want to say is that the national office at the ACLU has developed in connection with the Campaign for Smart Justice, which is a campaign the ACLU is running trying to impact mass incarceration. We are looking at trying to file 10 lawsuits in the next 3 years against prosecutors, and we are looking to engage in 10 prosecutorial elections. And so one of the things we would like to go out is, to the extent that you have information that would be helpful on prosecutor practices or on prosecutors who are coming up for election, and maybe there are people in your communities that are interested in running against them. The ACLU is nonpartisan, so we cannot endorse a candidate, but we can, as was done in Philadelphia. You mentioned Mr. Krasner, who was elected there. The ACLU did a major campaign of going out into the community and just talking to people about the kind of policies prosecutors should be pursuing, and saying, we're not talking about any particular candidate, but here are the policies. And then when they go and look at the election material, it just so happens that one candidate has all those policies and the other one doesn't. So contact with your ACLU affiliate in the state where you practice may be a way for you to give us information that we can make use of as we try and have an impact on prosecutors as well. And Angela, I'm wondering, is there anything you can say or any thoughts you've had about the electoral process? Because you've said good people should run for prosecutors. Do you have thoughts about where we might find them, or how people in our position can get engaged in that electoral process?
Yeah. So in this last, back in 2016, George Soros of the Open Society Foundation funded an effort that was kind of on the DL, but it's not anymore, where he basically funded these political action committees that would kind of do sort of a little bit of what you were talking about, Jeff, that ACLU is going to do, which would be to go into these jurisdictions where there is a bad prosecutor that everybody knows has had bad charging policies and all of that, and engaged in misconduct or whatever, where there's been someone who wants to step up and challenge them. So they didn't fund the person who was running against them, but they did information campaigns, and they funded folks to go out and knock on doors and get people to come out and vote. Change.org, also y'all might be familiar with Rashad Robinson's organization, very key in that process as well. Worked really hard on seating these folks. And so I think they have been doing the work, and I think it's up to all of us to identify these bad prosecutors, first of all, and if there are people who are willing to challenge them and really support these efforts. I tell people all the time when I talk about the book and pay attention to your DA races. Nobody pays attention to that, primarily because if you live like in my jurisdiction for years, the same person ran for like unopposed for decades. There's only one name in the slot there. And when it was a bad person, I just didn't vote for him at all. If there were a couple times when it was a decent person, I'd vote for him. But most people don't pay attention to that race at all. And I don't even blame them because, again, prosecutors are so undercover about how when they run, they're like, I'm tough on crime. And then if there's an opponent, they say, I'm tougher on crime. And nobody talks about what's really going on. But I think that's changing now. But where can we find them? I mean, we hear of these egregious instances, and we all live in jurisdictions. I mean, we know some of us live in jurisdictions where there's a prosecutor who's really, a bad prosecutor who's engaged in terrible practices. I mean, y'all are defense attorneys. You may not want to run. Maybe you do. Talk to Larry Krasner. Maybe you do. But even if you don't, y'all are the folks who probably know who these bad prosecutors are more than anybody, because y'all are having to engage with them in your cases. And so I think it's about us in this room when we see these egregious cases. I mean, I knew Anita Alvarez was a horrible prosecutor long before the Laquan McDonald case in Chicago. Y'all familiar with Anita Alvarez? So, I mean, she was doing all kinds of the outrageous prosecutorial misconduct long before she failed to turn over that videotape that showed the cop murdering Laquan McDonald. That was what got her the national attention. But I knew she was terrible long before that, and though y'all in this room knew that too, but nobody was talking about, nobody seemed, she was even on 60 Minutes even did an expose on her exposing how terrible it was, and she was like remarkably frank. I mean, that's the arrogance of some of these folks. Like, they don't mind telling you the dirty stuff they're doing. They're like, yeah, I did it. I'm like, really? Wow. But it wasn't until the Laquan McDonald case that really she got this exposure. So my point is that we know who these prosecutors are. I mean, I think the key is exposing them, and even if we don't find people who want to run against them, educating the public about what they're doing. It's our job to do that. Not necessarily everybody who's out there in the, trenches, not in the trenches, I hate that term, in the work, in the hard work of doing the everyday work. But getting the word to, if you're at a public defender office, you're a chief public defender, or people who are the head of your bar, local bar, or whatever, to get the word out about these practices. I mean, it's important.
So you've talked about when you were running PDS that you would try and do some of these things, and I think there may be people here who run offices, or certainly folks here who are going to go back and talk to the people running their offices. Are there things that you might suggest that we should be saying to the leaders of these public defender offices about what they need to do?
About depending on who your boss is, you might not want to go in there and say, you need to do such and so. Hopefully, the lawyers in my office certainly did do that at PDS, back to the hiring people with a healthy disrespect for authority, right? So that was the job description, You hire them because they have a healthy disrespect for authority, and then
you're the authority.
Boss, and it's like they're like, I'm not doing what you tell me to do. And I'm like, okay, I did hire that. I did say that. But what you might suggest, how I use that
suggest
to them. Yeah, I mean, it depends on the jurisdiction and whether you have a forum for doing it. So a lot of times because it's kind of hard to sort of say, call up the pastor and say, hey, I want to come and talk to you. But if you're a member of a church, I mean, more and more churches, like I've been invited to some churches to talk about policing the black man. I'm so excited about that, that people in churches, they want to hear about that. So, but you may be a member of a church, you may be a member of a community group, you may be a member of the local NAACP or whatever. So if you are, then you can help to create that opening for the chief public defender to be invited to come there and to do a talk. But it's kind of hard for them to kind of go and say, hey, can I come talk to you? But there are openings, and people care about criminal justice issues these days. I really think they do. I mean, one of the it's not a silver lining, because there is no silver lining to all these horrible killings of these unarmed black men, but one of the collateral consequences, I don't know what the phrase I'm using, is that people are paying attention to our criminal justice system, saying, what the heck? I mean, this can't be. And so I think people have an interest And so getting them invited to come and talk about these issues, I think would be a great thing if they're willing to do it, because I do think it is their role to do this and not the role of the staff attorneys.
One of the people who spoke before you, Alex from the ACLU in New Jersey, talked about how as a public defender, we're always taught, and correctly so, taught it's clients over causes. We represent clients, not causes.
I agree with that.
And Alex was saying, as an activist lawyer at the ACLU, he still thought that was appropriate. But it seems like we are talking about a slightly different role than the one that we have traditionally thought of when we think of a public defender.
Well, I don't when it comes to people who are representing clients every day. I really do not. It is. I agree with Alex. I do think it's clients over causes. I mean, some years ago, Michelle Alexander, you all know her and the amazing, groundbreaking book she wrote, The New Jim Crow. She wrote an article some years ago in the New York Times about the plea bargaining system, and she was highlighting a group in California that was promoting defense attorneys telling their clients all to reject all plea offers and everybody demand a trial. And so she asked me, would I participate in such a thing? I was like, no, I would not. Mm-hmm. I get the point, the whole system blow up, revolution and all, everything. Yeah, I get it. But if I'm representing an individual client, and it really is a good plea offer, and if he really is going to avoid going to prison and avoid a conviction, I'm not going to tell him to reject that offer because a revolution going to come. No, I'm not doing that. You represent a client. And so, no, it is clients before causes. But what you said before, if you are in a position because you're the chief of that office and it's not affecting your representation of an individual client, absolutely, we're talking about a different way. If it's different for the chiefs of the offices, for the heads of organizations to do that, then we do need to do that. But no, individual defenders must always put their clients first. Be adversary in the court. You got to be, right? You got to protect your clients. You got to stand between your clients and that judge and that prosecutor, always. But yes, there is room, and there must be room for the chief defender to try to have that communication with the prosecutor and with the community about what prosecutors are doing.